And welcome back to No Kings on the Hill. I am Dr. Hill. Sorry, running a couple minutes late today. Thanks for joining us tonight on episode 35. We are live every Wednesday at 5 p.m. Central, 6 p.m. Eastern Time on Rumble, X, and Facebook at the Patriot Spirit Network, on YouTube and Facebook at No Kings on the Hill, on X at Dr. Law 42, and on Twitch at No Kings on the Hill. And if you can see our website down at the bottom of the screen, scrolling across there, No Kings on the Hill with drlaw.com, please take time to stop by there. That is where you can access links to all of our social media accounts, previous episodes, and other ways to keep up with what's going on with the show. There you can subscribe for free and have access to our weekly blog. If you'd like to help us grow this platform, you can subscribe to one of our paid tiers, which also allows us to continue growing and gives you perks as a subscriber, including but not limited to guest hosting opportunities, subscriber-only lives, Discord chats, and even a say in what we talk about next. And as always, if you're able to leave us a review, we'd love to know how we're doing. So please leave us a review to help us improve the show and reach more people. Now, today we're tackling a question that seems simple enough until you place the Constitution right next to it. When does election integrity become executive overreach? The Trump administration claims it is protecting the integrity of federal elections by strengthening citizenship verification, securing mail-in ballots, and coordinating federal voter data and postal procedures ahead of the midterms. That sounds like something that many conservatives will reflexively support. Only citizens should vote. Voter rolls should be accurate. Mail-in ballots should be handled with care. Election rules should be known before election day and not created afterward. But the easy question isn't whether the goal is worthy. The hard question is who has the constitutional authority to do it. State legislators are given the first responsibility for setting the times, places, and manners of congressional elections by Article 1, Section 4 of the Constitution. Congress can then alter those rules by the rules by law. The president is not given a blank check to rewrite election law whenever he signs an executive order with election integrity in the title. That tension is where today's debate lives, not in the lazy partisan version of this debate, not where one side acts like fraud isn't a concern and the other side acts like executive power knows no bounds. We're going to ask the originalist question. What does the Constitution actually give to the president, to Congress, and to the states? So I will check in to see, make sure everything's up. I'm going to get here started on my monologue here in a minute. So please engage in the comments once you get in or up. And if you have any questions, looks like we're just starting to get the count going. So hopefully we'll start seeing some more people in here in a minute. All right, I'm going to go ahead and get started with my monologue. So let's begin with something very conservative that should feel comfortable saying. Election integrity matters. Citizens should vote in American elections. Voter rolls should be accurate. Mail-in ballots should be traceable. Ballots should be handled according to clear rules, not vague promises from election officials or 11th hour bureaucrat patches like we're seeing in California. If a republic cannot make voters confident that elections are lawful, fair, and secure, it will struggle to make a case for every other political contest. So if the Trump administration says it wants citizenship verification, mail-in ballot security, federal data coordination, and improved chain of custody standards, conservatives should not oppose these goals. These goals are laudable. And in many cases, they are long overdue, which President Trump tried to get Congress to do in the SAVE Act. But constitutional conservatism cannot end at stating the goal. The Constitution then asks a second question: who has the authority to achieve it? And that is where this gets interesting. And frankly, that is where it gets uncomfortable for some folks on our side. The Constitution does not simply say, is this a good policy? Rather, it asks which institution can act under what authorization and with what limits. Elections are one area where that structure really matters. Article 1 vested state legislatures the primary authority to set the times, places, and manner of congressional elections. Congress can change those rules by statute. That is the constitutional framework. Legislatures first, then Congress, if Congress acts legislatively. The president's role is to take care that those laws are executed in accordance with the law. He does not have the authority to issue a parallel national election code through executive orders. This may sound kind of technical, but it isn't. It's the difference between constitutional governance and governance through administrative bypass. Which brings us to what is happening right now. The president's order calls for citizenship verification, federal data coordination, USPS rulemaking on mail-in and absentee ballot transmission standards, and USPS input into state ballot designs. Supporters see that and say, good, about time somebody was doing something about these vulnerable mail-in ballot systems. And I understand why President Trump did it. I mean, obviously, he's frustrated because the SAVE Act was supposed to pass to have all these things in it, but Senate Leader Thune can't get shit done. Now, obviously, critics read that and say, now the president is trying to federalize election administration and restrict mail-in ballot access through agencies he cannot constitutionally use that way. Well, they're partially right. He can't use them, but Congress can. Both sides are missing the most important question, and it's not whether we should have election integrity. Of course we should. The question is whether this particular exercise of power comports with the Constitution. All right. The post office is designed to deliver mail. It is not designed to become a national election board. USPS can set mailing standards. USPS may require ballots to be placed in machine-readable envelopes. USPS can institute tracking. Those are all reasonable things for the USPS to do as an element of its mail administration. But when the Postal Service begins making transmissions of ballots contingent on approval from federalized lists, state filing requisitions, or executive branch compliance officers, well, then we have to ask where mail-in delivery ends and election administration begins. Federal mailing standards, sure. Nationwide election law, lines have to be drawn somewhere. That is the line at issue here, because the president can say, I'm using USPS to secure elections, and that allows the executive branch to impose practical, if not formal, election rules on the states. Then what's left of the election clause? What's left of Congress's power? What's left of state legislative power? And conservatives should be very wary here more than most. We spent years crying foul when presidents used administrative agencies to achieve ends Congress did not enact. We balked when administrative agencies discovered huge new powers lurking within old statutes. We yelled when executive officials treated statutory silence as implicit permission. Well, they're still not entitled to implicit permission just because this president is issuing the orders. And we shouldn't suddenly declare that silence means consent because the orders sound like they might improve election integrity. The latter half of that statement is true. Mail voting creates chain of custody issues. Loose voter rolls are problematic. Citizenship verification is part of the solution. Late arriving ballots, signature comparisons, ballot curing, and ambiguous deadlines all undermine voter confidence. Campaigns should not be fought on vibes and trust us placards. But the solutions still need to be legal solutions. If Congress wants national proof of citizenship requirements for registering to vote in federal elections, it can debate and pass them if it has the will and the constitutional authority to do so. If states want stricter mail and ballot standards, they can pass those laws. If they want voter ID, pure rolls, timely receipt deadlines, or narrow absentee eligibility windows, they should seek those reforms through their lawful legislative process. Or even the federal government can ask for certain things of those when it comes to the Congress and the presidency. They can't ask it on state levels, but they can on the federal level. That is how sustainable election reform happens, not by having the president issue an order that requires the Postal Service to do his bidding in a role it was never designed to fulfill. This is another reason conservatives should be concerned about this approach. If you begin federalizing aspects of election administration through the executive branch today, you bequeath a weapon for the next administration to use tomorrow. We don't want to give that much power to Democrats once they get power back. They could use it for we use it for ballot security, sure, but what about ballot access mandates, federalized mail voting expansions, pressure campaigns against conservative states with independent election laws? Power stays in office far longer than it stays with any individual president. This is why the constitutional structure is not just a partisan luxury, it is a guardrail. It restrains our political opponents, but it also restrains us when we are tempted to take shortcuts on our own side. So here's what conservatives should be saying. Secure the ballot box, clean the voter rolls, verify citizenship, get Congress to pass the SAVE Act, get Leader Thune out of office, institute mail-in ballot procedures that promote integrity and public confidence whenever the law allows. But let's do it through the institutions the Constitution actually assigns to do that job. State legislatures, Congress. The courts are to apply the law. The president should take care that those laws are faithfully executed. Election integrity is too important to leave a constitutional orphan. Don't make the mailman our nation's election judge. And I know that it sucks, but it's the truth. And I understand President Trump's his anger and his reason why. I understand why he did this executive order, but it went too far, and unfortunately, because the Senate can't get their acting gear and can't pass a single bill almost the whole time they've been there. And after we elected them and gave them power to pass the agenda, you can't bypass that with a executive order, unfortunately. So please, if you're watching, please hit that like button. Please hit those like buttons, follow buttons, tap, repost, share. Let's get this out. Let's try to get some more people in here, especially people on YouTube. Please hit that like button so YouTube will push it out more. Same thing with if you're watching on Facebook or X or Rumble. So I'm going to get into segment 1 with what happened this week, or kind of happened last week, really, but in the last week or so. So we need to start with the basic facts on the ground. President Trump issued an executive order on March 31st entitled Ensuring Citizenship Verification and Integrity in Federal Elections. The order claims it will strengthen the integrity of federal elections by ensuring that every vote cast in a federal election is cast by a United States citizen who meets the eligibility requirements to vote in that election, improving the process for verifying voter eligibility and modernizing procedures for mail-in voting using the U.S. Postal Service. It leans on existing federal powers. In particular, it cites the Department of Homeland Security and the Homeland Security Act, the Social Security Administration, federal election law, and the obscurely worded but nevertheless real obligation of the federal government to protect Republican government in the states. The executive order creates something called state citizenship lists. These are lists of all individuals who have been confirmed to be citizens of the United States, are old enough to vote in the next federal election, and who reside in each state. The order also directs the USPS to begin rulemaking on mail-in and absentee ballot materials. This could include election mail markings that would constitute official USPS in the indice ballots or indicative ballot for ballots, automation compatibility, compatible ballot envelopes, tracking capabilities such as unique barcodes, envelope design, or procedures for state mail-in and absentee ballot participation list. Fast forward through lawsuits, challengers argue correctly that this order trespasses on the authority of the Constitution gives to states and to Congress. The short version of their complaint, the president can't rewrite election administration via executive order. If the rules governing federal elections need to change, Congress needs to change them. If rules governing elections inside states need to change, state legislatures can change them as long as they abide by the Constitution. On May 28th, or it was, well, it's actually later than that, but after a couple days after the very end of May, beginning of June, Judge Carl Nichols on the Federal District Court in Washington declined to put the executive order on hold. Now, that sounds big, but don't let me oversell it. Judge Nichols is not the Supreme Court. He did not issue a final blessing on everything in the executive order. It was merely a preliminary posture ruling. And also, he said that he couldn't rule on it yet because not enough of it had gone to an effect. That wasn't to say that he wouldn't rule on it later on. He just said enough of the executive order had not fully gone into effect for him to rule on it. Essentially, his logic was that the lawsuit was brought too soon. The Trump administration has not actually implemented the executive order in a way that injures the challengers. The state citizenship lists haven't been created, much less shown to be defective. USPS has not created final rules that harm the plaintiffs or their members. So for now, Judge Nichols says no. This means two things at once. First, the executive branch gets to keep working for the time being, but second, the constitutional fight is far from over. If DHS and SSA manufacture citizenship lists that kick eligible voters off, if USPS finalizes a rule that changes how mail-in ballots are treated, and if states feel coerced into complying with federal dictates, the challengers will be able to return to court. And that's what makes this such an excellent podcast topic. We don't have a completed legal narrative to discuss yet. We are watching the very beginning of a constitutional showdown that could impact the 2026 midterms, or really more in the 2028, since the midterms are pretty much already fully into effect. Obviously, we don't have the primaries until, not the primaries, but the general election until November the 3rd. But the Supreme Court has already ruled that you can't change election laws right before an election. Now, they never really have given a definition on whether it's a day, weeks, months, a month, 2 months, 3 months, we don't know. So obviously that's still kind of pushing it there. And why does timing matter? Well, election rules are always a sensitive subject, but election rules are especially sensitive during election year. The courts don't like to see things changed on the eve of voting. Think about what election officials are doing right now. They're trying to finalize systems, ballots, deadlines, envelopes, voter education materials, poll working trainings, etc. If the federal agencies suddenly weigh in with new rules or regulations, even well-intentioned adjustments could confuse voters and poll workers. So when we say the Trump administration won in court this week, we're not telling the whole story. What we should really say is the administration survived the first early stage legal challenges because the judge believed the case was brought too early. Now we enter the real fight over implementation. What will the agencies actually do? What will USPS actually propose via rulemaking? How will states react, especially if they don't like USPS proposals? And when does a theoretical constitutional question become an injury that courts can correct? Those are the questions we tackle for the rest of the episode. So let me see how this Congress is effectively performing a coup on our constitutional. They are traitors, not. Not like I said, Anita, I don't disagree. Like, I understand why President Trump's doing it, but unfortunately, constitutionally, it's not a good thing. And also, like I said, we don't want to give that much. We don't want to give that much. We don't want to give that much power to the next Democratic president, as they could go in there and just try to make everything easy and just open everything up. And that's the last thing we need. So, segment 2, the strongest conservative case for the order. And like I said, there's certain parts of the order that could go through. It's just there's parts of the order that are way beyond the power of the president to an executive order. Like, and I'll get into this more, but him actually requesting USPS to require the mail-in ballots, the scan, the barcodes, tracking like that, chain of custody, that's well within it. So here's how I'd make the case, obviously, for the Trump order. First, federal elections are national contests with national implications. The federal government has an interest in ensuring only lawful voters cast ballots. That's not extreme. That's not authoritarian. That's Republican government 101. But here's what the trick is citizens alone should vote in federal elections. We know that. If we can't say that with clarity and force, we've already lost. Citizenship is not some technical hoop. It's the legal confirmation of membership that entitles someone to help choose a nation's government. Second, the federal government can claim that states sometimes lack the best information. Immigration databases, citizenship records, SSA databases, and federal ID systems have traditionally been managed at the federal level. If the federal government has information that could help states ensure their voter rolls are accurate, why wouldn't they want to use it? And pretty much what this executive order did is pretty much enacted the majority of the SAVE Act minus the ID requirements is what it did. So, I mean, that's the strongest argument is if DHS and SSA can provide information to confirm citizenship in a lawful and accurate manner, state election officials might actually benefit. Voters might benefit. The system might, again, be trustworthy. And that's what we got to look at. And obviously, third, mail-in balloting changes the equation. Mail-in ballots are not inherently suspect. They just create a different set of vulnerabilities that in-person voting does not. When someone votes by mail, a ballot exists. A polling place is a controlled environment. It enters homes, drop boxes, local clerk's offices, the mail stream. It might be requested online, issued, mailed, received, remediated, changed, challenged, counted. Any of those steps can be completely secure, but each step also needs to be designed correctly because they can easily be corrupted or defrauded. Again, this is not paranoia. This is thinking about process integrity. And we've seen issues with it all over the United States of process issues that have shown up. So the argument goes, ballots are being mailed under the United States Postal Service. The USPS has an operational interest in making sure ballots are mailed securely. It can require ballot envelopes that machines can read. It can track ballots with its technology. It can ensure all election mail is marked as official election mail. And if election mail is robbed, delayed, forged, or otherwise illegally used, USPS can coordinate with election inspectors and local law enforcement. Fourth, voter confidence is part of the equation too. Conservatives shouldn't be ashamed to say that confidence in the system matters. True election integritists believe legal compliance is its own reward. They will insist that a voting system can be fully legally compliant even if most people don't believe it's administered fairly, equitably, or transparently. I don't agree with that view. If enough voters believe elections are rigged, they will be rigged, not in a legal sense, in a practical sense. Campaigns will evolve to exploit public suspicions. Partisans on both sides will believe the other side is cheating. Nothing illegal necessarily occurs, but constant assertions of cheating tear down faith in the democratic system. So, yes, the president can say that this executive order is about confidence, is about making sure voters can know their ballots are only going to eligible voters. It's about ensuring mailed ballots can be tracked. It's about taking federal law seriously and accurately enforcing it. It's about ensuring there are real consequences for election fraudsters. Fifth, the president also has an argument under existing law. Congress has already banned certain forms of election fraud. Congress has already legislated a federal voter registration law. Congress has already imposed national standards on parts of the election process. The president is not creating new power out of whole cloth. He can argue he's merely directing the executive branch to use tools already granted under existing law. There is an honest debate to be had about the efficacy of various election integrity reforms, but some of the criticism of these reforms has been downright unserious. Trying to verify eligibility equals voter suppression. Really? Come on. Cleaning voter rolls is actively wicked. If ballots don't arrive by election day, democracy dies. I mean, none of that is analysis. That's pure biased messaging. Yes, there is a case for election integrity reform. Citizenship matters, voter rolls matter, mail-in ballot security matters, voter confidence matters, and the federal law matters. But insofar as President Trump issued an executive order about election integrity, does he have the constitutional authority to do what he's done? And that's the question you really got to ask. And like I said, I think some of it went a little too far and went a little, if he had stuck with just the USPS stuff, left out the save database, the Social Security, and all that for the citizenship verification, I think the executive order could have been ruled fine. And who knows, a judge may rule that that part is good and they rule that the other part is not good. I guess we'll see once they feel like enough of it's been enforced and the policy's been drawn up and they decide to go forward on it. But if anybody's doing here, please tap that like, repost, share. Let's try to get some more people in here. Share this out. Get it going live. I mean, we've got a decent amount of people going right now, but let's get some more going and see if you can tap those screens. Like I said, repost, share. Let's try to get some more in here. I'm going to get started with segment 3, the constitutional problem. So obviously, this becomes the question. The constitutional issue is not that election integrity is bad. The constitutional issue is that the election authority is delegated. It's assigned. It belongs. It does not wander around Washington looking for the most energetic branch to seize it. Begin with the Elections Clause. Article 1, Section 4 states the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the place of choosing senators. That matters. The first actors are state legislators. The national actor is Congress, not the president through an executive order. Not DHS through a database, not USPS through mail rolls, Congress through legislation. That is the default for originalists. Election rules matter. They are not mere administrative details. They allocate power, political power. That is why the Constitution gives them politically accountable lawmaking bodies. Congress can defer to the executive on any specific item. The president may have a role. He shall take care that the laws be faithfully executed. He can direct executive branch agencies within legal bounds. He can enforce federal election crimes. He can insist that agencies obey federal statutes. He can require executive branch coordination. But the president does not get to create state citizenship lists. Faithful execution is not lawmaking. Coordination is not legislation. Agency management is not the same as creating an electoral accountability structure outside our federalist system. So when this order tells the Attorney General to establish state citizenship lists, we should ask where these lists are legally sourced. Are they mere recommendations? Are they optional tools that states may consult? Or do they become, in reality, de facto gatekeeping tools that determine who receives a ballot or who has their registration challenged? If these lists are purely informational, that solves a big chunk of the constitutional problem. Federal agencies provide information to states all the time. But if these lists become requirements for ballot access, or if they become tools the executive branch can weaponize to strong-arm states into refusing voters, well, then the constitutional problem escalates very quickly because this is done through the president, not through congressional legislation. This applies to USPS too. USPS can make rules about the mail. It can decide that an envelope must be machine readable. It can decide that certain barcodes are required to track the envelope. It can decide on operational standards for how ballots are processed. That is USPS administering the mail, which is why I was saying those certain issues that Trump had put in the executive order will work. But if USPS essentially decides that it will not transmit ballots except pursuant to a federally created and approved state participation list, or if it essentially decides who can and cannot receive mail-in ballots by creating a gatekeeping tool for states, well, then USPS has also moved past mere administration into something that affects election rules. And that is where conservative rhetoric should scare. For years, we have decried administrative creep. We have criticized administrative agencies stretching decades-old statutes to create new federal programs. We have criticized presidents issuing executive orders to accomplish what Congress refused to do. Again, like I said earlier, we have criticized the notion that because Congress used a broad phrase in a statute, they can become a blank check for sweeping national policy. All that was correct, but those criticisms only applied when Democrats do it, when we both do it, when Democrats and Republicans do it. If we believe in the major questions doctrine and non-delegation principles and separation of powers, and in the idea that federal agencies need clear congressional authorization before they make massive policy decisions that reshape entire fields of law, then we ignore all that when the policy we like is proclamated. No, never mind, stop that thought process right there, because the principles still apply. The principle has to survive contact with our political preferences. All right, there's also a federalism question here. States are not federal agencies with local offices. State election officials run federal elections, but they do not do so pursuant to state law and federal statutes. They do not do so because the president tweets he is managing elections or because he appoints them to their jobs. If the executive branch begins pressuring states with federal agencies to adopt certain election procedures without congressional authorization, that is a federalist problem. That's a violation of federalism. Some will argue that Congress has already legislated and preempted the field on issues like voter registration laws and election crimes. Of course they have. That is not the question we're asking here. The question is whether Congress has authorized this system. Has Congress said that states must participate in this system of state citizenship list? USPS ballot transmission rules establish participation lists and interagency cooperation in administering elections the way this order demands. That is what the legal fight is about, not slogans, not, oh, libs would do this too, legitimate authority. And if the answer is unclear, conservative originalists should not presume that the ambiguity should be resolved in favor of the executive. We should be concerned about granting vast power to a single set of officials. Even if our party controls those officials, true originalism does not care about team loyalty. A good test of our thinking about this order is to reserve the powers. Imagine the same system in place, but under a Democratic president. Imagine the president issuing an executive order telling USPS to ensure that every state adopts broad universal mail-in voting, votes past election day. Imagine the order pressured states to expand ballot access. Imagine the order created federal lists to direct ballot distribution. Imagine the order said federal agencies should coordinate with states to ensure states adopted the administration's preferred approach to elections, including letting everybody vote, even illegal immigrants or people visiting. I mean, would conservatives applaud that order as justifiable election administration? Or would we call it an executive branch seizure of the election process? Of course we would. I don't think that test answers every legal question with this order, but it does highlight whether we are actually thinking through principles or have simply decided to abandon the form because our team made the policy decision or because Congress won't get their ass in gear and pass a bill that literally does everything that is listed in this executive order, plus require voter ID. I mean, that's literally the only thing that President Trump didn't put in this order was requiring voter ID. Everything else that he's put in here with the USPS implementation, the SAVE database, all that is in the SAVE Act. We need Leader Thune to nuke the filibuster and pass the damn bill. Simple as that. But he won't, because he's a globalist rhino who doesn't care about doing what's he was elected and put in office to do again. He only cares about doing what's best for his lobbyists and donors, friends, and his globalist elitist friends. That's it. So please like, share. Let's get some comments going. Tap that screen. Share with some friends if you think they'd enjoy the segment. Also, please go to the website, follow, sign there so we can get on the I got a set up a Discord chat so you can start asking or requesting specific topics on what to cover, because obviously the main topics right now are election and election integrity, election, what's going on in elections and Iran. But obviously you can only do so much about those. Hopefully we'll start seeing some new Supreme Court rulings coming down along with election day, the election day definition, and obviously the 14th Amendment birthright citizenship ruling, and a bunch more that should be coming between June and July that we should start seeing here pretty soon. So obviously once those come in, I'll start doing some episodes on those. When the new Affordable Housing Act or Affordable Housing for the 21st Century Act the amendments get passed and that gets President Trump's desk, I'm going to do another episode on that. So those are some topics that I'm looking at covering coming up. But I will go ahead and get on to segment 4, which is the USPS and implementation problem. So let's talk about implementation, because election administration is where good ideas go to become complicated. USPS is a gigantic operational agency. They process mail, they work logistics, delivery routes, sorting machines, barcodes, facilities, inspection guidelines, delivery standards, and statutory frameworks. It is not a tribunal of election eligibility. That's important because there are mail-in questions and election questions. Mail-in questions: can this envelope be processed through a machine? Does it scan correctly? Is it tagged properly as official election mail? Can it be tracked? Can USPS diagnose where delays are happening? Those are legitimate mail questions. Those are questions, appropriate tasks for USPS to handle. And if that's all the administration orders, executive order said, we'd be fine. Election questions are different. Who is entitled to receive a ballot, while which deadline controls? What happens if a ballot is mailed to a voter who appears on a state list but not a federal list? What happens if a voter is eligible to be registered under state law but is missing from a citizenship verification database for state? What happens when a name mismatch addresses mismatch naturalization delay or database glitch creates an issue? Those are not USPS questions. Those are ballot access questions that need to be decided at the federal or state level. This is why the structure of this proposal matters so much. If states are going to mail-in list of mail absentee ballot participants to USPS, and if USPS is going to use those lists to drive decisions about how that ballot mail is handled, then it is critically important to know how USPS will handle all the errors and exceptions. Will they deliver the ballot anyway? Will they hold it? Will they return it? Will they flag it? Will they contact the state? Will they contact the voter? Will there be a cure process? Who pays for the system? Who is liable if the system screws up? And all of this needs to be figured out before the midterms. This isn't theoretical. Election administration is busy work. Ballots have to be designed, printed, sent out, received, and tabulated. Voters need to know what to do. Poll workers need to be trained. Election officials need to order supplies. Software vendors need to write programs, and local officials need to test those programs. We're months away. We've only got a couple states left with the primaries of elections, and we're months away from the actual general election. If a new federal layer is suddenly added to this process, that creates massive confusion, even if the goal is well-intentioned. Now obviously requiring voter ID, that's the easiest thing that can happen. That's the easiest thing to implement. All the other stuff at the mail-in ballots and absentee ballots and the way that they're verified and checking the state list and checking your voter rolls and clearing those and the cures and the transportation, that stuff gets a lot more in depth of being able to track it correctly. Conservatives should care about this. As conservatives, we love to attack election chaos. When rules are changed close to an election, we rightfully say that this undermines voter confidence. When judges and officials rewrite procedures weeks before voters head to the polls, we say rightfully that this is unfair. Look at all the calls coming out about the mail-in ballot system in California. That literally takes, there's third world countries that can count ballots in faster time than the state of California can. And third world countries that are that are same size as California can count ballots faster than California can because of how screwed up their mail-in ballot system is. Obviously that's unfair to everybody to have to wait that long. When voters and poll workers don't know what ballots look like until it's too late, we say rightfully that the rules should be stable. We're about to see this play out with USPS if it goes forward. Suppose the post office and other federal agencies finalize these systems too late for state vendors to incorporate them into their software. What happens then? Suppose mail delays cause ballots to arrive late. Suppose voters receive different instructions about what to do if the mail is delayed. And then we got the other question that's, I kind of didn't put this in there, but the other question we're going to have coming up is once the Supreme Court gives the ruling on what's the definition of election day, that could change a lot of the state's mail-in ballot rules too. So we're going to have to see what happens with that. And obviously, with the bigger Supreme Court ruling earlier this year that now allows you to challenge election rules before the election, you don't have to wait till after the election and show injury first. We're probably going to see a whole lot more election challenge laws challenged, period, both sides, Republican and Democrat. Suppose there's a raft of legal uncertainty about how these eligibilities lists interact with state rules. Confidence in the election will suffer. Voters will be confused about those are outcomes conservatives correctly warn about every single election cycle. Here's the other problem. There is no perfect database of American citizens. Heck, there is no full list of American citizens compiled by the federal government. Naturalized citizens don't always appear correctly in outdated databases. Name change, address change, sometimes databases contradict with each other. People move, sometimes the federal records that are perfectly acceptable for one purpose, e.g., can this person buy a gun, are insufficient for another. What happens if a state uses a partial federal list to double check voter registrations? That's annoying, but it might be okay. But what if the full power of the United States Postal Service intimidates states into using an imperfect federal list as a gatekeeping device before mail and ballots are even printed? That's much worse. In fact, that could be unconstitutional. Well, it would be, but that's why the judge's ripeness decision is so important. The judge basically said, hey, we don't know if these lists will cause concrete harm. But plaintiffs, you can come back to us when the final rules go into place and when you have the final lists, if you can show that the final decision causes specific injuries. Smart plaintiffs' attorneys know they have time to investigate how the final rules will work on the ground. Implementation is not a side note. Implementation is where lawyers will look for constitutional violations. It's where they'll go after it for. Conservatives want to avoid operational nightmares and unconstitutional overreach, but please understand that those two are distinct. Those are two distinct things. Just because the post office can create a system does not mean the post office should be empowered to dictate new election rules unless Congress passes that law. Or more accurately, can USPS track ballot envelopes? Of course they can. Should USPS become a federal gatekeeper over mail-in ballot eligibility unless Congress specifically gives it that power? No, they should not. And I love it how everybody says they always think you have to agree with everything. If President Trump does something that you don't like or don't agree with, then all of a sudden you have to hate him or something. You don't agree with everything your wife or husband does. You don't have to hate somebody just because they do something you don't agree with. Like I said, I understand why he did this and his frustration about it. Doesn't mean I agree with him doing it. It doesn't mean I agree with it going forward because it would broaden the administrative state, not reverse or pull back the bureaucracy like he's been trying to do for a long time. And this could have an opposite effect of what he's been trying to do by tearing down the deep state and the globalists. You give more power to the administrative state in this area to enact an executive order like this, that'll set new precedent come when it's time for Democrats to take office. And like I said, what happens when they decide to tell all the states, hey, you have to let everybody vote. It doesn't matter if you can no longer check for their you can no longer check their IDs. You can no longer ask for their citizenship. You can't clean your voter rolls. You can't do any of that. You just have to let everybody vote. I mean, if this executive order gets ruled constitutional, that is a technical situation that could happen based on putting that authority into the president's hand instead of Congress's, because they can't get off their asses to work because they don't want to work in the hard stuff or force, even if they don't nuke the filibuster, you could force a talking filibuster, which would still get us to the end to actually get the vote where you need the simple majority. But they don't want to do that. They want to allow Congress to be able to call a filibuster without actually getting up and debating, because originally that's what a filibuster was. Filibuster meant that you had arguments against a bill and that you wanted to go on the floor and have time to air your grievances to hopefully convince certain people to change their votes. And that was the whole point of it. now they can sit there and claim that they filibuster it, but they don't actually have to get up and stand and do any negotiating. So it's a whole lot easier to filibuster when you're not having to get up there and stand for hours on end until all 50 or however many of your all 100 senators have gone up there and talked. You don't. So it's a whole lot easier for you to call filibusters when you don't have to do that. If they would actually go back, either one, remove the filibuster or force them to do the talking filibusters, you would see a lot less people filibustering bills because they wouldn't want to waste the time airing out their airing out hot air just to know that they're going to lose anyways, unless they actually believe somehow that they could convince a couple votes to turn. There would be no point for them to spend all this time debating in the Senate. It would save us a lot of time. It would get a lot more bills passed, even with the filibuster still in place. But for some reason, they still don't want to do that. Also, before I get started in this next segment, please, like I was saying, hit that like button, repost, share with anybody you know. Also, follow if you aren't already following. We're live every Wednesday at 5 p.m. I do have guest hosts on sometimes. Last month, I had 2 different guest hosts. I had Sheriff Mack and the owner of Ironhawk Financial. Going to try to get a couple creators from TikTok this next month and get them on here. So please hit those like buttons and follow buttons. Like I said, check out the website and let me know what topics you'd like to see covered next. As far as segment 5 go, it's how conservatives should talk about it, obviously. So how do we talk about this without succumbing to either of the traps that we've talked about? Trap number 1, the left's trap. Pretend like concerns about election integrity are inherently illegitimate. That's wrong. Clean voter rolls, citizenship verification matter. Lawful deadlines, chain of custody, transparent counting procedures, these aren't attacks on democracy. They're conditions of democratic legitimacy, so we don't lose our democracy, so people can trust it and more people actually show up. I mean, facts have been proven that when people trust in their voting elections, they trust in the integrity of their votes in their elections, they actually show up. More people show up to vote versus the numbers going down like Democrats want to push. Because obviously, trap number 2, our own trap, is going into this fight automatically assuming that any policy can be dubbed election integrity and therefore be beyond constitutional questioning. That's wrong too. We cannot treat the Constitution as just a list of outcomes that we prefer. What's the better conservative position? There's 4 things that is. Number 1 is say yes to election integrity. Obviously, that's the most simple thing to agree with. Do not apologize for wanting secure elections. Only citizens should be voting. States should have accurate voter rolls. States should require voter IDs. Texas requires voting IDs. I just went to vote in the primary runoffs, and they actually scanned my ID to ensure that my ID was actually a real state ID, that it wasn't a fake one, that it could actually be scanned and I was who I was. And Texas has had voter ID in place for a long time. And I'm sorry, but our minority voting percentage has not gone down. We have not seen less minorities voting. We've actually seen our minority voters go up because, again, people feel more secure and more believe that their elections have integrity and that they're secured. So they actually show up to vote. They don't believe that people who aren't supposed to vote are voting when you have to show your ID. It's simple as that. Obviously, states should have accurate voter rolls because some people own 2 different properties. And while you can vote state level, they should also know that you're in 2 different states so they can mark on there that you're not allowed to vote in federal elections, which is why there should be a state ballot and a federal ballot, not all one ballot. Because that's another issue, is when states don't have separate federal and state ballots and somebody has land in one state, lives in another state where they have a guest house or whatever, but they still are voting at the state level because they have a right to vote at the state level for city, county taxes, everything like that, because they own property in that state. So they have the right to vote for representation who represents the property or land that they own. But they don't have the right to vote at the federal level. You can only vote from the one state that you live in at the federal level because the fact that the federal level, if you vote in 2 states, you're getting a double vote. When you vote in one state and vote in another state at the state level, you're not double voting. You're voting for your representative in the state that you live here in your main home and then your vacation or second home. So yes, states should have accurate voter rolls and they should be clean consistently. Mail-in ballots should be trackable, auditable, and subject to clear deadlines. Election officials should not be making up new rules on election day, which Supreme Court has decided that. Like I said, now it can't be on election day. It has to be. They really didn't say a time, but they said it can't be right before the election. The Supreme Court really didn't say, and I've read the case, it didn't say a week, a month, really define it really well, unfortunately. Number 2 is say yes to federalism. States have real power over election integrity or election administration. It's not absolute power. Congress can legislate under the Elections Clause and elsewhere, but the president doesn't get to stand in Congress's place. Number 3, say yes to Congress doing its job. Does the country need national election integrity standards? Obviously, it does. Then Congress should debate them, vote on them, get their ass in gear. Claim them as their own policy. Presidential action can be quicker, but quick is not the same as legitimate. Number 4, say yes to limiting executive president. If you applaud the executive branch doing something today, they will discover tomorrow how to do it a little differently. And that's what we don't want to happen. And that's not a conspiracy theory. That's just how constitutions work. Offices are forever, people are not. This isn't perfect messaging, but it does give us conservatives a serious principled position. We support election integrity so as long as it's pursued through lawful means. We believe in citizenship verification, but we want systems that are actually accurate and legally authorized to verify citizenship created through Congress. We want mail-in ballot accountability, but we don't want the USPS transforming it into an election judge. We want federal enforcement of federal law. We do not want executive agencies writing new election rules that Congress chose not to enact. There's an easy position. Neither side will pick that fight on your terms, but it's a better position than what either side will offer in talking points. Plus, it actually leads to reforms we can get behind. States can restrict mail-in ballot eligibility. States can improve voter roll maintenance. States can establish cleaner receipt deadlines. Crap, the federal government can do it at the constitutional level. They can enforce states to enact that. States can consider voter ID laws to comply with constitutional jurisprudence. Congress can standardize proofs of citizenship rules if it really wants nationwide election administration. It can also require voter IDs at, again, the federal level. Obviously, it cannot require voter IDs or citizenship requirements at state level, but it can at the federal. Again, I still think we need a federal system separated from we need our federal system and our state system separate because of the fact that the states are allowed, state rights give them the ability to allow whoever they want to vote for governor, for mayor, for city council members, for judges, whatever. But federal voting is set at the federal level. So that means Congress and the House and Senate make the laws on who, and the Constitution makes the rules and regulations on who and who can't vote in presidential and congressional elections, which it's been decided that you have to be a citizen of the United States to vote in those. You can only vote in one state on the federal level. It's simple as that. We got to make sure that that's enforced at that level. I mean, obviously, Congress can fund improved database integrity. Congress can clarify what USPS is and isn't allowed to do with the election mail. So we need, again, this is all in the SAVE Act. We need Congress to get its butt in gear. Well, not really the House, the Senate. Can't say Congress itself because it's not the Senate's problem. I mean, the House's problem, it's the Senate. The House has passed over 380 some odd, 400 and some odd pieces of legislation. The corresponding bills passed in the Senate have been like, I think 78 now, which just shows how how bad this Senate's doing. And it's just despicable that how little this Senate has gotten done because of John Thune not being able to, being a sorry leader, honestly. I don't understand why we have not forced everybody that's a Republican needs to call their senators and tell them to put a vote for no confidence up on Thune. He needs to be removed from leadership, and they need to place in somebody else, Mike Lee or somebody else who can actually pull the Republicans together, get them, whipping them into vote in the shape for votes, and that can actually has the balls to do what's needed to lead the Senate to get bills passed for what they were actually put in office to do, for the piece of legislation that people voted them in office to get passed, which was the president's agenda, the Republican agenda. That's what they need to get done. But with Thune standing in the way, they're not getting shit done. So, I mean, obviously all these things are slow. Persuasion is slow. Voting is slow. compromise is slow. That is the point. The Constitution is supposed to make it very difficult to create durable national policy, except through the people's elected representatives actually owning that policy, which unfortunately, that's where our administrative state is blown up. Our administrative state has started giving our Congress, our representatives, the ability to not make all policy. They'll make a broad bill that'll state, hey, Department of Housing and Urban Development, we would like for this instance to happen. Do what you need to do to make it happen. And then so the real legislation, the real meat of that legislation and that policy is created by the administrative agency. Obviously, that's a broad generalization. It's an exaggeration points, but you get the point. I'm not going to go into all the technicality and the legal, all the different aspects of what can happen, what can't happen. But in general, that's the way it works. It's a simple explanation. Obviously, a simplified one, but it is what can happen. And it's what we've seen happen with the administrative state growing so vastly, and why we've seen so much stuff happen, and why executive orders have become such a big tool. And where if you go back before, if you go back to like Reagan, back before the 1970s, executive orders were never used because, I mean, well, the administrative state wasn't really created till after World War II. But it didn't really start grow. It grew under. It was created under FDR. It started growing. Then it really got big under Truman and everything else after that. And it started growing and growing. And obviously, as it got in the 60s, it grew anymore. 70s, it massively grew. And now the administrative state is where it's at. And you've got senators attacking Marco Rubio in a committee meeting because they're pissed off because he destroyed USAID, which was literally a front for the CIA. So I think that brings us all the way back to the title of the episode. Is Trump's executive order election integrity or executive overreach? The best answer might be yes, it is executive overreach. The goal of election integrity is good. Part of the method he chose through those seems like executive overreach. Recognizing both of those realities at the same time is something that I think constitutional conservatives should be big enough to handle. It's simple as that. So getting to, before I close up here, just seeing if there's any more comments. Not really today. You got 300 people in here live, 279 on the native. Thanks for joining in. If y'all are on the natives, please also check out my No Kings on the Hill page on either my Facebook or YouTube, and then also on my No Kings on the Hill, my Twitch, or you can check also out my Dr. Hill Law 42 on the my X channel. I'd love to see you check that out or check the website out and join me there. But I'll go ahead and get ready to close it up here. We've got a couple minutes left. So before we go, let's finish with the takeaway. Election integrity is not a battle cry. It is not a partisan mascot costume. It is not something we whip out only when we lose or put away when we win. Election integrity means the rules are legal, clear, consistent, transparently applied, and administered by the entities entrusted with administering them. Citizenship verification matters. Mail-in ballot security matters. Voter roll accuracy matters. Chain of custody matters. But who draws the boundary on who controls elections matters too. If we want long-lasting election reform, if we want reform that will actually survive court challenges, drive it through state legislatures and Congress. Enact the laws, set the standards, write the procedures, let voters know who's calling the shots, let courts hold people accountable to those rules. Stop trying to build your ideal election system on executive orders and hoping the next president doesn't mess with it. The strength of our republic isn't determined by how much power belongs to a single branch if they have good policies. It's strengthened when good policies are enacted through their proper channels. All right? That is what constitutional conservatism demands of us. It demands we say yes to election integrity and yes to reining in executive power simultaneously. So I want to thank you for joining me tonight on No Kings on the Hill with Dr. Hill. I'm your host, Dr. Hill. If you liked this episode, if you found it helpful, if it helped you connect some constitutional dots behind the headlines, please like, subscribe, share this show with someone who needs to hear it, and leave us a review while you're at it on our website, nokingsonthehill with drhill.com. Let us know how you think we're doing, where you think we're spot on, or where we missed the mark. Also, what stories do you want us to cover next or in the future? And then, like I said, as you see the website's going across the bottom of the screen, No Kings on the Hill with drlaw.com. Please click over there and spend some time with us. Catch all of our past episodes and current ones. It'll give you link to all of our socials, and then any ways you can support the show. You can always subscribe for free to access our weekly blog, or if you want to help support us and get access to some really great perks, you can subscribe to one of our paid tiers. And on the paid tiers, obviously the subscription helps us bring you more content and grow, and hopefully start doing more than one show a week. Our paid tiers also offer opportunities to engage with us monthly, opportunities to be a guest host on the show, subscribe-only live streams, Discord chats, and other stuff. So you can obviously nominate for the next topic we cover and whatever episode you'd like to see. And then remember, we go live every Wednesday at 5 p.m. Central, 6 p.m. Eastern on Rumble, X, and Facebook via the Patriots Prayer Network. Additionally, we are on YouTube and Facebook at No Kings on the Hill, on X at Dr. Law 42, and Kick at No Kings on the Hill 41, I think. As always, we cut through the slogans, we cut through doomer memes, we cut through the political theater, because this republic doesn't survive on hashtags. It survives on when we drive toward truth. It survives when we re-engage with the law, with order, liberty, with a constitution that actually means what it says. And if tonight's episode did anything useful, I hope it helped remind you that good policy and constitutional principles have to travel together, even if we don't like it. Being right about the problem is just half the battle. We have to be right about the solution, and we have to be right about who has the authority to implement that solution. Otherwise, free people keep pulling themselves back from the cliff of reform as a new era of rule by administrative convenience begins to take shape. So keep those emails coming. Keep letting us know what you want us to tackle next. Keep sharing this show with your friends, family, coworkers who you know are thirsty for something more than panic and screaming monkeys on cable news. You grow this with every share that you send our way, and believe me, I don't take that for granted. Until next week, stay informed, stay engaged, stay grounded in our Constitution, and remember, no kings on the hill, only we the people and the rule of law, and I'll catch you on the hill.